All warfare, the ancient Chinese general Sun Tzu wrote, is based on deception. And to deceive one's opponent, one must know something the opponent doesn't. The same holds true in business. In today's world of electronic commerce, the computerized trading system that acquires vital information a fraction of a second faster than another system can initiate hundreds or even thousands of profitable transactions before its rivals catch up. Updated news and information has always been important in business. And when it comes to information sharing, as the Supreme Court said in the 1817 case of Laidlaw versus Oregon, all's fair in business and war. Or is it? By the beginning of 1815, the War of 1812 between Great Britain and the United States had been dragging on for nearly 3 years. Negotiators had reached a peace agreement in December of 1814, but it had to be ratified by both governments before it could take effect. In the meantime, the state of war continued, including a British embargo of American exports. Without access to British markets, prices for many American products, including tobacco, were depressed. On the morning of February 18, 1815, a man named Oregon was negotiating to purchase tobacco from Laidlaw and Company, which we'll call Laidlaw. But the night before, Oregon had learned from British naval officers that a peace treaty had been signed. Oregon knew that once news of the treaty got out, tobacco prices would immediately rise in expectation of the embargo's end. So Oregon hurried to complete the purchase from Laidlaw's agent. The agent asked whether Oregon had heard any news that might affect their transaction. Oregon said he hadn't, and the parties signed a bill of exchange for 111 hogsheads of tobacco, or about 55 tons. Laidlaw delivered the tobacco to Oregon later that day. By the next day, word of the peace treaty spread in handbills and newspapers. The value of tobacco immediately jumped by 30 to 50%. The day after that, men from Laidlaw forcibly stole back the tobacco they had just delivered to Oregon. Oregon sued Laidlaw in the United States District Court for the Louisiana District, seeking the return of the tobacco. After the trial judge instructed the jury that Oregon had no duty to reveal what he knew to Laidlaw's agent, the jury found for Oregon, and the court ordered that the tobacco be returned. Laidlaw sought review in the United States Supreme Court.